My name is Cullen Jones, and I'm a governor on the Florida Bar's Young Lawyers Division. On behalf of the Young Lawyers Division and the Florida Bar's Labor and Employment Section, thank you for joining us today for our COVID-19 and Return to Work webinar. This webinar will cover what employers and employees need to know. And we have for you a very nice slate of lawyers, two of which are from the Jackson Lewis firm, and they will give the view from the employer's perspective. And we have Michelle Nadeau from Qual Barrick Nadeau, who will give the employee perspective. We will reserve some time at the end for question and answers, and some of the speakers may wish to answer questions as they arise. So we encourage you to use the Q&A tab at the bottom of the screen. Without further ado, I'd like to introduce the speakers. Our first speaker is Tyler White, and he is a principal in Jackson Lewis's Jacksonville, Florida office. He represents and counsels employers in all aspects of public and private sector employment-related issues. Our next speaker is Brian Hayden, and he is an associate in Jackson Lewis's Jacksonville office. He also represents public and private employers with respect to complex employment law issues. Our next speaker is Michelle Nadeau. She is a board-certified labor and employment lawyer representing employees. She is with the firm of Qual Barrick Nadeau in Clearwater, Florida. She has previously served on the L&E Employment Board Certification Committee for the Florida Bar and is a past chair of that committee. She represents employees in litigation involving employment discrimination, harassment, wage and hour laws, employment contracts, and non-compete agreements. With that said, I will turn it over to the speakers to begin the webinar. Thank you.
Thanks so much, Cullen. This is Tyler White. I want to thank everyone for joining us today. I'd also like to thank the Young Lawyers Division of the Florida Bar for asking us to speak and partnering with us on this webinar. We all greatly appreciate the opportunity to speak to you all today on what is obviously a timely topic, but maybe it's a topic you've heard a lot about lately. You may have even attended a lot of webinars about it, but we'll kind of deal with a scenario-based situation so you can understand how we as employment lawyers, both on the employer side and the employee side, are viewing the COVID-19 pandemic. So we titled today's topic, Legal Landmines, Navigating Return to Work Scenarios During COVID-19. But many of the scenarios that we're going to discuss today, and really the underlying principles of how employers should be thinking about how handling these scenarios with their employees, could really apply anytime. Furloughs, layoffs, returning employees to work while still navigating the effects of the current pandemic has already proven to be immensely challenging for employers and employees. And at least until a vaccine is widely available, it seems to us that this will continue to be challenging for employers on a number of fronts. And it looks like my internet is reconnecting, so hopefully I will get back up here. Can everyone hear me?
Yes, we can hear you.
Okay, sorry about that. My internet was telling me it was going out. So the first thing I'd like to do is remind everyone of some critical resources that are available on the internet.
You need to share your screen again.
Oh, I need to share my screen again? Okay, thank you. Brian, I don't know if you can take control.
Yeah, let me see if I can go ahead and share my screen.
My apologies. And I'll try to get up and running here.
Can everyone, is that up and running? Can you see the agenda?
We can see your screen. It looks like it's there's different it's not the main slide. You can see the next slide.
Okay, one moment.
How's that?
I think you fixed it.
Okay.
Okay, I see. My apologies. Of course, technology would get in the way here. So the first thing I'd like to do is remind you of some critical resources. Brian, if you could back up the slide once. Thank you. The first is the Centers for Disease Control and Prevention at cdc.gov. Keep this tabbed on your browser for the latest on safety protocols, of which you'll need to remain aware. Our firm's website, jacksonlewis.com, also has a wealth of resources that are available for review. In particular, we have a COVID-19 advisor, which is really an interactive resource that's updated daily with information on business openings, closure orders, mass gathering limitations, federal, state, and local leave laws, health and safety protocols, CARES Act unemployment insurance information, and state disability and workers' compensation guidance. The other resource that you'll want to review is the Department of Labor website. They're constantly updating their guidance and frequently asked questions at dol.gov regarding the new legislation, the Families First Coronavirus Response Act, which expands FMLA leave and provides emergency paid sick leave for certain eligible employees of employers with less than 500 employees. It also contains guidance and information regarding OSHA, wage and hour, and unemployment compensation issues. Finally, of course, you'll want to bookmark the EEOC's website, eeoc.gov, because it contains updated information about discrimination considerations, particularly with respect to the Americans with Disabilities Act during the pandemic. And, as an employment lawyer, again, representing exclusively employers, and Michelle will talk to you from the employee side of things, but as an employment lawyer, it's a good idea for my clients, for example, to review things like the EEOC and the DOL guidance, because when we're talking about legal landmines, if the DOL and the EEOC are taking the time to answer specific questions about how to handle certain situations, it's because they're receiving these questions from employers and employees. So when employees come to them, for example, because they believe they've been wronged in their employment, if the employer has deviated from how the EEOC or the DOL recommends that an employer handle a situation, that could, of course, form the basis for a claim. Now, as I said, Brian and I exclusively represent employers in employment-related litigation, and Michelle represents employees. Over the past couple of months, since the pandemic hit, as an employment lawyer speaking for myself, I've had to provide more advice and counsel on a whole gamut of potential issues than really any time I can remember. First and foremost, in my experience, employers do want to do the right thing by their employees. Michelle will give her perspective from that on that situation. But by that same token, when employers are faced with difficult decisions for their business, employers really don't want to get sued for the actions that they take. No one can stop an employer from getting sued, but from our view, there are some ways to handle situations that allow you to treat employees fairly and with dignity while complying with the law. And again, from the defense perspective, putting themselves in the best defensive position if they have to explain to a judge or jury in litigation why they took the action that they did. Brian, if you could advance the slide. The reality is that we expect litigation against employers to ramp up now following the furloughs and the layoffs that occurred during the pandemic. And for that reason, you'll see when we talk about some of the scenarios today involving telecommuting, employee safety concerns, and leave requests, The three main questions I look at when an employer is taking any action involving an employee are, is this action lawful? Has the employer communicated enough with the employee about this issue and properly documented that communication with the employee? Can the employer clearly explain what happened and why it's taking the action that it's taking? And does the documentation that they have line up with that explanation? If you could advance the slide, Brian. So again, as employers looking to defend, as employment lawyers looking to defend employers in litigation, it's important that that employers understand the context of what was happening in the world at the time any issue arose, because that context is going to be an important aspect of an explanation that they give for why they took the action that they took with respect to their employees. So the advice is, of course, to stay up to date with the legislation, with the public directives, with the guidance from the CDC, the EEOC, and the DOL, because if employers are making decisions based on old or outdated data, that's going to expose their decision-making as flawed. Likewise, if they make rushed employment decisions without contemplating all of the potential ramifications and taking into consideration what the employee's version of the story is going to be, then that decision-making could look arrogant or worse, simply uncaring about employees, and Michelle will tell you all about that. Of course, legal landmines come in the form of discrimination and harassment. If you could advance the slide for us, Brian. And this discrimination and harassment can be based on age, disability, race, national origin, sex. Now sexual orientation is a federally protected characteristic, and all of the other characteristics that are protected by law. They can also come in the form of the claim we see most often, which are retaliation claims. This is where the employee has complained about alleged violations of the law or otherwise availed themselves of the protections of the law and then claim that they've been retaliated against with an adverse employment action, usually in the form of a termination. Another key thing that we are seeing a lot of now, and you're probably seeing a lot of it now, whether it's in your firms or if you handle these type of claims, you're probably seeing them, but trying to manage leaves of absence is a very tricky landmine. Claims for failure to engage in an interactive dialogue with an employee about accommodations for their disability is a claim we expect to see more of during the pandemic. Claims that an employee was made to work off the clock are also expected to increase. Privacy and cybersecurity concerns abound. Work from home environment. We'll talk a little bit about that. We've already seen lawsuits filed related to health and safety issues. Workers' compensation claims are likely to increase if your employees test positive for COVID because of someone they came into contact with while working for an employer. Finally, we expect to see an uptick in claims for failure to comply with the WARN Act when conducting mass layoffs. But I'm sure Michelle might agree that could be its own webinar. But if we could, Brian, go ahead and advance the slide for me. Did you advance the slide, Brian?
Yeah, you should be on slide age discrimination.
Got it. Thank you. So now I'd like to discuss a specific legal landmine, age discrimination. The EEOC has specifically identified age discrimination as a cause for concern during the pandemic. And this is particularly tricky because you may have noticed in many state and local orders, the older population is referred to as more vulnerable to the effects of COVID-19. And what we expect to see sort of borne out from the pandemic are more claims that employers have discriminated against employees over 40 years of age by laying them off, but keeping the younger workers or returning the younger workers and, refusing to return the older workers back to work after furlough. Or when the older workers come back to work, not providing the older workers with as many job assignments. We also expect many employers will state that they had benevolent reasons for doing so. They wanted to protect their vulnerable workers from the effects of COVID-19. And this is where age discrimination claims can kind of combine with disability discrimination claims. When employers are thinking really about the questions that I mentioned, what I like to ask is, are they making any assumptions about whether this employee can or should return to work? Or have they communicated with the employee enough about the issue to have a clear explanation for the action that they ended up taking? So, Michelle, I'm going to turn it over to you. Before Brian walks through or introduces us to an age discrimination scenario, why don't you weigh in here from the employee perspective?
Sure. So from an employee's perspective, I would say we were, going back to what you were talking about, we were not quite as busy when COVID first hit as you all were, because your employers were having to make all of these decisions. And we were really just getting a lot of calls about unemployment from people. So that was what we were spending our time doing. And since things have settled down a little bit, we are starting to get in the regular calls. It's a little different because people are legitimately getting terminated. It's a lot harder to find a discrimination claim when you're laying off everybody. And even mass layoff claims, like Warren Act claims, are difficult when there's there's an unforeseeable circumstance that happened, like COVID. So I would say that my practice has changed significantly as far as intake these last 6 months. But we're starting to figure it out. There's these new laws, they've given us this regulation, so we're doing this. I did want to add on to your last slide about the benevolent reasons. So you and I might disagree as to whether or not the employer has or wants to do the right thing, but even if we assume that the employer is acting with the best intentions, they cannot make decisions based on age or disability, even if they think they're protecting their employees. I had a case early on in my practice that was a pregnancy discrimination case, and at trial, the testimony came out from her supervisor that she was reassigned because the supervisor thought that she was doing her a favor, that she was putting this pregnant woman in this safer position. And what the jury ended up having to be instructed was that didn't matter. The good reasons didn't matter. And we won that case. We got a favorable jury verdict. And the reason for the pregnancy discrimination didn't matter because it was still discriminating against her because of her pregnancy.
Yeah, absolutely. And that goes back to sort of what I talked about, which is the employer making an assumption? Is the employer simply doing something that they think is in the employee's best interest without talking to the employee and really engaging with the employee? And, we would advise against that for just that very reason. Brian, I'm going to turn it over to you to run through a particular scenario involving age discrimination, but I think you'll see that disability discrimination questions also creep into this fact pattern.
Okay, thank you very much, Tyler. Thank you, Michelle. Good afternoon, everyone. As Colin introduced me earlier on in this presentation, my name is Brian Hayden. I'm an associate at Jackson Lewis's firm in Jacksonville, Florida. I'm going to circle back and discuss a little bit about a fact pattern involving age discrimination. So what I'd like to do is walk us through a return to work scenario that presents various legal landmines in the context of age discrimination and in particular COVID-19. Now, as we walk through the scenario, we'll identify what these potential landmines are and discuss some practical, hopefully hands-on ways that we can help our clients either avoid them or diffuse them. So let's go ahead and get started then. All right, in the scenario that we're looking at here, we're dealing with an older gentleman named Bob. Bob is 63 years old and works full-time in a warehouse loading and unloading boxes. Now, back in April, Bob, like millions of other employees across the country, was furloughed due to a work slowdown caused by the coronavirus. Bob's supervisor at that time, Regina, was the one who had to tell Bob that he was going to be furloughed. So Bob, when he first hears the news from Regina that he's going to be furloughed, he starts talking out loud, basically thinking out loud, and tells Regina, now might be a good time for me to retire anyway. This is a young man's job, and my diabetes, by the way, has really been taking a toll on me. Now, Regina, when she hears this, obviously not having gone to her employment counsel for advice, she tries to empathize with Bob and relate to him. And she tells him, I get it, Bob. You know, I'm 52, and it would be hard for me to do what you do, much less at your age and with diabetes to boot. You know, let's play it by ear for now, and we will be in touch. So Bob agrees with his plan and goes out on furlough. So now, if we fast forward a few months, it's now September, and Bob's company, like many of the companies our own clients are at, begins to consider returning Bob and other furloughed employees back to work. Now, Regina decides that she's actually not going to offer to return Bob back to work because she thinks that she can maybe hire someone else at a lower wage than Bob's, and that the new worker might even be faster and better at the job than Bob was. Since this plan seems good to Regina, she sends a completely non-privileged and fully discoverable email that's probably going to be an exhibit number 1 in a lawsuit to Jack in the Human Resources Department, and that email states, Bob told me he was too old for this job, he wanted to retire, and he was concerned about his diabetes with COVID right now. We can also probably save some money on a new hire. So, like many of you are hopefully thinking right now, when Jack gets this email, he thinks to himself, you know, I think we might have some problems here. So what are some of the legal landmines that have come up in this situation? Well, some of the obvious ones are obviously Regina's exchange with Bob of age-related comments such as, now might be a good time for me to retire. This is a young man's job. It would be hard for me to do what you do, much less at your age. Now, while these might be seemingly innocent phrases at the time, I can guarantee you that in hindsight, and in the context of an age discrimination lawsuit, there are landmines that, for the employer, from its perspective, are just waiting to explode. So another problem just waiting to happen is Regina's non-privileged email to Human Resources, which, as you can imagine, can easily be interpreted as a manager deciding not to return an employee to work because he's, quote, too old and has diabetes. Now, while Regina might be thinking that Bob really didn't want to return to work based on what he told her, what she doesn't realize is that Bob has had several months sitting at home, being bored, watching Netflix, Amazon, and he decides, you know what, he actually likes working and wants to work and looks forward to being called back from furlough. In addition to all that, you know, Bob's taking a look at his bank account and savings account, retirement accounts, and he realizes that, you know what, even if he wanted to, he probably couldn't retire right now anyhow. So when Bob learns that he's not going to be called back from furlough, he decides to hire himself a lawyer and see if he can increase his retirement savings perhaps quicker than he otherwise might be able to. So after Bob meets with his lawyer, from our perspective, having dealt with these claims many times, I can guarantee you that he remembers his conversation with Regina in a very different light than Regina does. What Bob's going to most likely tell the court and the jury is that Regina recommended to him that he consider retiring and suggested that he might be getting a little bit too old for the job. Bob's also going to recall that Regina did absolutely nothing when he told her that he was concerned about his diabetes, especially in light of the coronavirus. He's also going to recall that she didn't ask him if he needed any type of accommodation, and you know, she didn't mention the Family Medical Leave Act to him, or if he wanted to explore the possibility of perhaps taking FMLA leave. Now, in addition to all this, Bob's going to tell the court and the jury that he remembers that Regina and other employees actually made, you know, several age-related remarks both to and about him. He recalls them saying things such as like old-timer and maybe giving him sidelong, disgusted looks when he took a break to take his insulin. anything he can remember related to age discrimination and disability discrimination. Those things are going to come out. So in a nutshell, Bob and his attorney are going to do their best to take what are these potential landmines and see if they can turn that into a claim. So the question then becomes, how do we help our clients avoid or diffuse the landmines that we just went over and ran across? So one thing that we can certainly do is advise our clients to train their managers and supervisors who are conducting the furloughs and layoffs to avoid talking about protected categories or characteristics in their decision making. In other words, we need to tell our clients to train their managers and supervisors to avoid basing decisions based on protected characteristics like age, sex, disability, race, all the protected characteristics that Tyler had mentioned earlier. Now, in this day and age, most people are aware enough not to make overtly discriminatory decisions. And I say most people because sometimes you have people slipping up. But in most cases, where the problems tend to come up is in situations where people are making well-intentioned decisions based on protected characteristics. And this goes to what Michelle was talking about earlier, perhaps making a decision for what seems to be a benevolent reason, but it's still based on a protected characteristics. You might have an example where a manager who's concerned about an older worker or older people with underlying medical conditions being more at risk of developing complications from COVID-19, that manager might decide to recall younger workers from furlough rather than older workers out of a concern for their health and safety. Now, that well-intentioned decision likely will lead that company to find themselves in the middle of a discrimination lawsuit or a charge of discrimination. So what are some other things that we can do to help our clients avoid the landmines that came up in the Bob and Regina scenario? Well, another thing I would suggest is that we advise our clients to get legal counsel involved in the discussions, especially about adverse employment actions. If you're considering layoffs or anything involving the employee and a protected class. Now, in the scenario that we just went over, Regina's email to Jack in Human Resources is completely discoverable, as we discussed and mentioned, and it's likely going to end up as Exhibit 1 in front of a jury. Now, in comparison, if we took that same email, if that same email had been sent by Human Resources to an in-house lawyer or outside employment counsel, it would be protected by attorney-client privilege and would never be seen by either the plaintiff or his attorney. So to wrap up then, from the employer's perspective at least, rather than not call Bob back from furlough, what Regina should have done is give him the opportunity to return to work with an authorization from a medical provider. And that authorization would obviously assure the company that it was safe for Bob to return to work, both for himself and others. So that wraps it up from the employer's perspective. Michelle, did you want to go ahead and jump in and give some thoughts from the employee's perspective on this scenario?
Sure. So, in this case, the employer didn't have the great advice of Brian and Tyler here to do the right thing, and they did lay off Bob. And if Bob walked in my door, or well, I guess we'd be Zooming now, this is a case that I would consider taking, because I think there's enough there to show that there was some age-related reasoning behind the decision. When you have an employee who has possibly been discriminated against at work, the first step is to file a charge of discrimination with the Equal Employment Opportunity Commission or the Florida Commission on Human Relations or a local entity. And there is not a lot of downside for an employee who believes they were discriminated against for filing that charge to get some more information. They don't even need a lawyer to do that. They can do that on their own, and it doesn't cost the employee anything. So in this situation, I can't see why Bob wouldn't file that charge of discrimination, because there are those statements in there. Bob wouldn't know about the email yet, but if it went to litigation, he would get it. And the main question I would ask Bob is whether other people were laid off. If he's the only one who was laid off, that's an issue. If he was one of 50 or 100, that's very different, because there's going to be a lot of comparators who were not old or disabled who were also terminated. So that would be that's the main thing that I'm looking at these days, is how many people are being affected by this. Does it look like there's really discrimination here, or is this person who is older or disabled getting caught up in a larger non-discriminatory termination? And then from, as a plaintiff's employer, I'm always looking at damages. Did Bob get a new job really quickly? Is he making the same amount of money? And things like that, because you can have the best liability case in the world, and if there's no damages, then that's an issue, a legal issue that you're gonna face in litigation. So those are the things that I would look at if Bob came to me after this.
Great, thanks, Michelle. Appreciate that insight. All right, we're going to pivot away slightly from age discrimination and talk about some of the other landmines that our clients could be aware of in the context of disability and leave absence management, both of which are bound to come up in the context of returning to work and in this COVID-19 scenario that we find ourselves in. Now, one issue that we'll want our clients to be aware of are potential failure to accommodate claims that might come from employees who say they are at higher risk for severe illness associated with COVID-19. These include employees with respiratory issues, diabetes, high blood pressure, for example, anyone who might be immunosuppressed or immunocompromised in any way. If an employee makes your client aware that they are at high risk, your client's going to want to be sure to engage the person in an interactive dialogue to help explore whether any accommodations are needed or can be provided in that situation. Similarly, employees with mental health concerns such as anxiety, depression, or panic attacks, all of which might be exacerbated or obviously heightened during these scary and uncertain times, should also be communicated with to explore whether any potential accommodations are needed or can be provided. One other landmine that you and your clients will want to be aware of are requests to work from home as a reasonable accommodation. Some of these requests may stem from a fear of exposure to the coronavirus, or fear that the employee may spread the coronavirus to a high-risk individual with whom they live. When it comes to these types of requests, employers are going to want to tread very carefully and be open to being more flexible than they otherwise would have been before or pre-coronavirus. Now, above all, you're going to want to make sure your clients are sure that they engage in the interactive process to be sure they understand why it is the employee is asking to work from home. Employers will want to avoid making assumptions and decisions before having all the facts. To give you an example, if an employee might not be entitled to a reasonable accommodation under the ADA, it still may be the case that they may be entitled to leave under the Families First Coronavirus Response Act, perhaps, or the FMLA. At bottom, your clients won't know unless they get all the facts. So it's worth engaging in that dialogue and digging a little deeper to find out why it is exactly you're being asked for this accommodation. Now, please keep in mind that when you advise your clients to engage in the interactive process, that you make sure that they don't push too hard and ask for medical information to which they are not entitled. Now, as I'm sure you know, while an employer can certainly ask that an employee's medical provider, complete a medical questionnaire designed to assess whether the employee can perform the essential functions of their job with or without a reasonable accommodation, they're not entitled to know everything about that person's medical history. So with that, I'll go ahead and turn the presentation back over to Tyler.
Thanks, Brian. So during the pandemic, if you've listened to any of these type of webinars, from an employer's perspective, the thing I'm hearing most is the phrase, be flexible. Be flexible with your employees, be flexible as a business in how you're dealing and handling with these issues. Don't do any knee-jerk reactions to anything or make impulsive decisions. And, what I'd add to that, I would say, be flexible is good advice, but I'll also add be vigilant. And this particularly applies to disability and leave of absence management. Dealing with leave issues for an employer, it can really be one of the most time-consuming and difficult aspects of managing employees. And I'm sure Michelle can weigh in on some things that she's seen with employers where employers just seem to sort of be fed up with the employee and probably makes a rash decision that is potentially discriminatory on the basis of that employee's disability. When an employee misses work or needs to take a leave of absence, on the one hand, employers are dealing with managers and supervisors who need to continue operating the business. And, so they're looking, for example, for their human resources department to magically come up with a solution to help them deal with a leave of absence of employees. And on the other hand, employers have to be sensitive to the reasons why the employee has missed work or asked for the leave of absence. And they want to be sensitive to that while also complying with the various protections surrounding that employee's right to take leave in certain situations. And for that reason, being vigilant as to the legal landmines associated with disability and leaves of absence is critical. Employers really need to be organized, thoughtful, and clearly document the progression of these events and their communication with their employees about these issues. The employers want to communicate with employees, and above all else, as Brian said, don't make assumptions related to the employee's alleged disabilities and what they can or cannot safely and successfully perform. Employers are not in a position, in most cases, unless they actually are a doctor, but employers in most situations should not play doctor and have a supervisor diagnose an employee based on what they're viewing. Leave that to the medical professionals, and that's always the advice we give employers. Because a lot of assumptions get made about what employees tell employers, and so we want to make sure that doesn't happen. But let's walk through a disability and leave of absence management scenario. So in this case, the employee Jennifer informs the company that she works for that she's tested positive for COVID-19. The company provides her with 2 weeks off of work, and the company wants to protect its workforce to allow for adequate precautions to be taken. So HR basically sends an email notification to all of the employees in the company to inform them specifically that employee Jennifer tested positive for COVID. Jennifer's doctor then clears her to return to work after 2 weeks. But Jennifer is really having difficulty obtaining a doctor's note clearing her to return to work. And from the employer's perspective, they're still kind of concerned about Jennifer and other employees. So the company requires her to remain out of work for an additional 2 weeks. And the company's stated reason is, hey, we want to ensure you're not contagious. So if you can move to the next slide, Brian. After Jennifer returns, her coworkers, they refuse to eat lunch with her. And her supervisors even, they avoid giving her assignments so she doesn't have as much work to do. And also after she returns to work, the company so happens to look at its workforce and has to make some decisions regarding reducing the workforce due to some of the business slowdowns associated with the pandemic. Now, Jennifer's an average employee. She's not, the top performer, but she's not on any type of performance improvement plan or anything like that. And she's among a number of employees that are selected for the layoff. Now, where are the legal landmines here? Well, if you can go to the next slide. The first incident of legal landmine is the failure to treat medical information obtained during employment-related medical examinations and inquiries as confidential. I mean, the main thing that I see here is when the company emailed all of its employees and specifically identified Jennifer as the employee who had received COVID or who had gotten COVID. And that's an issue because you're disclosing medical information about a specific employee. I get it. The employee themselves may have told all of their other coworkers that they got it, and everybody knows because of that. But there should not be a communication from the employer to employees specifically identifying Jennifer as a person who got COVID. And so that's something that the employer has an obligation to keep and treat confidential. They have an obligation to maintain that confidentiality regarding medical information. Jennifer could claim that she was regarded as or perceived as disabled under the ADA as a result of the COVID-19 diagnosis. At this point, we're really unsure if COVID-19 is going to be considered a disability under the ADA. It may be that it's unlikely that it will because it's kind of like the flu. It's temporary, it's transitory, presumably. But if an employee has it for an extended period of time, does it then become a disability? Does it cause long-standing neurological issues that manifest themselves in disability themselves? So, that's something that we have to consider and that an employer should consider. If you'll go to the next slide, Brian. So generally an employer's request for a return to work doctor's note is lawful. But if you look at some of the guidance from the EEOC and many state and local administrative agencies after the pandemic hit, because requests for medical notes related to COVID-19 could place excess burdens on the healthcare system, I think some of that is obviously the burden is probably lessening right now, hopefully, as cases seem to be trending downward. I mean, we'll knock on wood, but we could see spikes here in the fall. But employers shouldn't request medical notes to confirm disabilities related to COVID-19. That's what the EEOC guidance kind of says. But the other legal landmine is discrimination, harassment, hostile work environment based on coworker treatment, an inability to receive assignments after returning to work. And really this sometimes applies anytime an employee goes out for some type of disability-related leave or an extended leave and then comes back. If they're ostracized in some way by their coworkers, they can claim that that's creating a hostile work environment for them. Inability to receive assignments could end up affecting their performance. And if they receive a negative performance review because they're not, producing 100 widgets as they're required to do because they're not receiving assignments that require them to complete 100 widgets, they could potentially legitimately say in that situation, Jennifer could say that, the fact that her supervisor is ignoring her when she returns is a form of discrimination based on potential disability. And then is there a retaliation claim for taking leave? Did the employer, because of what appeared to be at least 4 weeks out, did the employer provide Jennifer with a notice of her FMLA rights, the Family Medical Leave Act? Does this trigger that? I think these are questions that the employer should be asking as they look at this scenario. But Michelle, I think there's a lot in this scenario. If you could give us some of the employee side perspective on this, I think that would be great.
Sure. So when there's a bigger layoff and you're evaluating the case of one employee that's part of that layoff, it's harder because there's going to be a lot of comparators, right? There's a lot of people who were laid off at the same time, and probably a lot of them did not have COVID and were not treated differently and did not take leaves of absence. So, the employer is going to be able to point to those people and say, we laid off all these people and they, are not they're not in that same protected category. The only in mass layoffs or bigger layoffs, employers are required to give the ages of the employees, so you can quickly evaluate an age discrimination claim in a bigger layoff. But for everything else, you kind of have to say, well, let's look at this list. What do you think? These other people. And, I'd want to know if there were any other evidence that she was chosen because she was sick or because she took leave. that is outside of just the regular layoff, because she can be included in the layoff having just returned from a leave. But if she's included because she returned from a leave, that's where the unlawful action takes place. But I do think that it's a lot harder in this situation. Sometimes you're able to negotiate a little bit of severance for someone in that kind of situation if they're already offering it. But it does become difficult where there are more people. And, you know, employers are usually smart enough to include people who are not in protected categories along with people who are in protected categories, so that they're, you know, they're not only laying off the old people or only laying off the disabled people. So I think that, you know, that becomes just more difficult. As far as the doctor's note, I can tell you, having talked to a lot of employees who have had to get doctor's notes over the years, is that sometimes that is a difficult task, especially for low wage workers. Sometimes they don't have access to medical care. Sometimes they have to pay, you know, you have to pay $70 every time you go to the doctor, or the doctor charges for the FMLA paperwork, and they can't afford that. That becomes a real hurdle for some people. So I would hope that employers were flexible where they can be with respect to requiring doctor's notes.
Yeah, that's great. Thanks, Michelle. I think, you know, you were talking about the layoffs, and when there's a number of people laid off with someone, maybe it's harder to prove or to have support for potential discrimination. So in that case, it sounds like you may look for other comments and things that suggest discrimination specific to that individual, I'm guessing.
Yeah, if, you know, if I'm talking to her, she says, well, you know, this comment was made by my supervisor, or this was made, then maybe there's something. But this probably isn't somebody, based on the facts that I know, that I'm necessarily going to encourage to go file a charge of discrimination.
Understood. Okay, I'll turn it over to Brian to walk through another disability and leave of absence management scenario.
Okay, thank you, Tyler. Thank you, Michelle. All right, everyone. I'd like to walk you through a second return to work scenario that presents various legal landmines related to disability and leave management as well. In this scenario, we're dealing with a manager at a retail store named Nancy. Nancy informs the company that her husband has high blood pressure and that she's concerned about exposing him to a higher risk of severe illness from COVID-19. Nancy asks whether she can work from home 100% of the time as a reasonable accommodation for her husband's disability. Now, what do you guys think? Is Nancy entitled to an accommodation? What would you say? If you answered no, you are correct. The ADA does not require an employer to accommodate an employee based on the disability-related needs of a family member or other person with whom she is associated. What the ADA does prohibit, however, is discrimination based on association with an individual with a disability. To put that a little bit differently, an employer cannot treat someone differently or harass them because they're related to or associate with someone with a disability. Now, in Nancy's case, in the scenario we just looked at, it's important to note that just because the company is not required to accommodate Nancy's request to work from home under the ADA, the analysis doesn't necessarily end there. It just so happens that the company is also allowing a male retail store manager to work from home because his wife has cancer and is undergoing various treatments related to that. In that situation, the company could be subject to perhaps a disparate treatment claim based on gender. So you want to dig a little bit deeper, get more facts, and make sure that you're not making a knee-jerk decision. In addition, it may be the case that Nancy is entitled to leave under the FMLA if her husband's high blood pressure happens to constitute a serious medical condition. Or she might be entitled to leave under the Families First Coronavirus Response Act for some reason unrelated to her husband that she hasn't mentioned yet because she thought that her first basis for the request was sufficient. But you don't know about that unless you ask. So again, engaging that interactive process, digging a little bit deeper, getting under the surface, finding out why it is the employee is asking you for the particular accommodation. Now, while the company obviously is not expected to be a mind reader, it's always a good practice, especially in the environment we find ourselves now with COVID-19, to always encourage your clients to engage in the interactive process and dialogue with their employees to understand, the full situation so that they can make an informed decision about what laws apply and what obligations that they may have. I'll go ahead and turn it back over to you, Tyler.
Thank you, Brian. So if you can go to the next slide, we'll do another scenario under the disability and leave of absence management, because I think it seems to me that these are the ones we're seeing the most frequently, these type of situations. So here, Andrew is an Asian American estimator. He works for a construction company. He suffers from high blood pressure and diabetes. The company in the past has accommodated him by allowing him to take breaks throughout the day to administer insulin. And so that you know, COVID-19, I guess I didn't provide this background information, but many of you may be aware of this because there's a lot of talk about it in the news, but apparently folks with, for example, high blood pressure and diabetes are particularly vulnerable to COVID-19, and they're vulnerable and susceptible. So because Andrew is basically high risk for COVID-19, he requests to work from home. The company says, we really need you on the job site. I mean, you're an estimator, you need to be there. Your job can't be performed remotely. So we're going to deny that accommodation request. Maybe the employer is very nice about it, as nice as they could be, but they deny the accommodation request. And Andrew says, well, you know what? A job doesn't do me any good if I get COVID-19 and I pass away. So he resigns out of fear for his health. He does not want to go to the job site. And that's the scenario. So where are some of the legal landmines there? I think that the Americans with Disabilities Act requires employers to engage in an interactive dialogue with employees. And I'm not sure that the employer under this scenario, with the limited information we have, really did that. I think Andrew, they knew that he was at high risk for COVID-19, and maybe he told them that. They knew he had the high blood pressure and the diabetes. He requested to work from home. Instead of the company saying, well, let's talk about this. What are your concerns? What could we do? Instead of even engaging in that, they just say, no, you should be on the job site. That's it, denied. And that could potentially be a failure to accommodate. Employers may be required to provide reasonable accommodations to employees with underlying conditions for whom exposure to COVID-19 could pose that particular risk of complication. And one of the ways to do that is to allow them to telework. Now, maybe that doesn't exactly work for Andrew. Maybe the majority of his work is on a job site. Okay, well, engage with him about that. And if the majority of his work is on the job site, then what is his concern? Presumably, it's coming into contact with other people. And so could we change his schedule perhaps? Could he come very early in the morning to do estimating on the job site when not a lot of workers are there? Could we make sure that he's allowed to distance from everyone? Obviously provide him with certain personal protective equipment when he's on the job site, things to make him feel safer. Maybe, work with his doctor with his approval by providing the doctor with his job requirements and what he'd be required to do, and asking the doctor how we could potentially accommodate him safely and successfully. And perhaps that gives the employee, peace of mind to do the job and do it safely and successfully. Now, a little wrinkle here. What if Andrew had claimed he requested to work remotely because he has anxiety and panic attacks that are exacerbated by the pandemic? Well, mental health conditions can be considered disabilities. So that's something that the employer will, of course, have to consider. But I think it goes back to potentially working with his medical provider with his approval to see what accommodations we could potentially provide as an employer to return Andrew safely and successfully to work. And, you know, of course, because we've mentioned that Andrew's Asian American, are there race and national origin considerations at play here? We don't know enough, I think, to say that there's any discrimination going on because of Andrew's race or national origin. But if Andrew knows of comments that are being made by his supervisors or even by coworkers, then that's something that I'm sure Michelle would want to know about. And so I'll turn it over to Michelle to let us know how she would evaluate this claim.
Yeah, so I would, I think given these facts, the first thing I would do is kind of dig into what conversations Andrew had with his supervisor, his employer, about the request for an accommodation. Because if it was a simple, I want to work from home, and then just a no, then that is, that can be an issue. Like you said, they do have to engage in the interactive process. Was there another accommodation that would have worked if working from home wasn't possible? Was working from home really not possible? So, you know, I think that work from home used to be a tough sell for an accommodation. I know that, you know, over the years, I've had a couple of cases where that's been the accommodation we said was denied, and there was not great case law out there. Really had to be the right situation. Now we kind of see that a lot of people can work from home that didn't. And when we all, you know, back in March, our laptops and went home, I said, oh, this is going to be interesting to see how this develops into request for reasonable accommodation. So I think that, you know, it's something that I'd really want to know what happened there. The employer doesn't have to give the employees preferred accommodation, but does have to provide a reasonable accommodation as long as it's not an undue hardship on the employer. If you're a bigger employer, it's going to be a lot harder for you to say you can't offer any accommodation. If you're a smaller employer, then, you know, it's going to be harder for you to find the right accommodation. So that's what I would look at. As far as race or national origin, I mean, I'll be honest, I let people kind of bring up the facts, tell their story, and then I try to find the pieces. I'm not going to say, oh, well, do you think it was because of your race if there was no indication when an employee is telling me the story. But that is an issue. You know, there are people out there who I think, especially at the beginning, but even now, you know, blame China for the virus and might be discriminating against people who appear to them to be Chinese. So, I wouldn't be surprised if there are more claims like that in the near future or currently already filed. But the other thing is, you know, that Andrew resigned, but even, you know, resigning is not the end of the story. A resignation can be a constructive discharge if they made his working conditions so unbearable that he was forced to resign. Then it can still be treated as a termination by calling it a constructive discharge. So just because your employee resigns doesn't mean you're completely out of the woods.
Absolutely. Thanks, Michelle. And I'll turn it over to Brian.
Okay, thank you, Michelle. Thank you, Tyler. Now, obviously, as we've been discussing, you know, working from home, telecommuting, it's going to be a big issue and something that I'm sure many of your clients and companies out there are currently trying to navigate. So the next topic that we want to talk about is how to navigate the return to work during COVID-19 and being prepared to defend decisions not to allow telecommuting as a reasonable accommodation going forward. Now, as I'm sure many of you have seen and experienced, an unprecedented number of employees have worked remotely over these past several months. I know myself personally, I've been working from home since about mid-March, and I'm sure many of you are probably listening to this webinar doing something similar. So as employers begin to transition work back to the office, there's bound to be some resistance and pushback, especially in light of people's fears about contracting COVID-19 and above that, possibly spreading it to loved ones at home and to people who may have underlying health conditions and be at a higher risk of severe illness. Now, in light of this reality, in order for employers to best position themselves to avoid or defend against failure to accommodate claims related to telecommuting, they are going to want to be sure to document the reasons for denying such requests. Now, this documentation should list the specific requirements of the job that cannot be adequately performed remotely. It should be noted, despite saying all that employers who have leaned especially heavily into telework during the COVID-19 pandemic, they're not automatically going to be required to allow the same accommodation if and when the coronavirus becomes less of a threat. Now, just last week, the EEOC issued guidance making this point very clearly. Although many legal commentators and attorneys speculated that businesses that transitioned their operations online during COVID-19 were going to have a tough time refusing telework requests going forward after the pandemic, the EEOC's guidance actually makes it clear that the legal landscape hasn't quite changed that much, and it hasn't changed permanently. In other words, according to the EEOC, once the COVID-19 pandemic becomes less of a threat, the question of whether or not telework is a reasonable accommodation is again going to require a very fact-specific inquiry and determination, just as it always has. The key for employers and our clients to minimize their risk is going to be to engage in an interactive dialogue with their employees to discuss whether or not telework makes sense under those circumstances, whether or not they can perform the essential functions of their job as it exists, or whether or not some other option exists. Now, if your clients engage in this type of interactive dialogue that we've been stressing during today's webinar, not only is it going to foster goodwill with your employees and give them the sense that their concerns are being listened to and heard, but it's also going to allow your clients to determine what, if any, obligations they have under federal, state, or local law to provide, either teleworking as an accommodation or some other type of accommodation. Finally, you're going to want to be sure to tell your clients to document the fact that all available options have been explored, both internally and with the employee, before they make any type of serious employment-related decisions, such as, firing an employee, terminating them, laying them off, especially during a pandemic. Michelle, did you want to provide the employee's perspective on any of those things that we just went over?
Yeah, so again, on the work from home, and this isn't necessarily legal advice, but, I'm an employer as well as someone who represents employees. And my advice to other people who are employers has generally been to be, as generous with telework as you can this year. While some jobs truly do need to be in person, a lot don't. It might make it slightly easier in person, but they don't really need to be in person. And if you can extend that benefit during this weird year, I think it can go a long way for, employee goodwill. I have 2 employees, one of whom likes being in the office and has come back for part of the time, and one who is not yet comfortable and she's not coming back. And it's one of those things where, I said, this is fine. This isn't forever. This is for this year. Eventually we'll have a vaccine. At that point, we can all come back and work together. But, we all need to get through this. And I think, trying to be generous with work from home and knowing that the guidance is that this doesn't mean you have to let this person work from home for the next 20 years can allow employers to offer that now.
Yeah, that's a great point. Thank you, Michelle. And that's something that we're stressing to our clients, certainly, is that just because you can doesn't necessarily mean that you should. Being flexible with people, giving a little more grace, and being a little bit more willing to engage in thoughtful conversation and be flexible during these circumstances is something that we certainly tell our clients that they should consider doing. With that, I'll go ahead and turn it back over to you, Tyler.
Thanks, Brian. So if you could turn to the next slide for me. And the next issue we received a lot of questions about, and we were certainly receiving a lot of questions about it early on. Then we started receiving more questions as it was clear that the pandemic was not just going to go away through the summer, and that this was going to affect the school year. So we continued to see more questions about this with childcare concerns. A lot of you are probably navigating this yourself while you're trying to possibly virtual school your children and work at the same time. It's quite a juggling act. Employees are also, many employees are dealing with that. But what if an employee says that their child's school has closed, or that their child has to quarantine for 2 weeks because of an outbreak at their school, or if their school decides to close altogether due to COVID? And what if their child is asthmatic and they don't want to just put them with any child care provider? I think you need to engage in a conversation with the employee as an employer. Ask the employee if they have any proposals for how they can continue to do their job while their children virtual school from home, and some of them are probably doing it now. Is telework available for their job? If the employer has less than 500 employees, it would likely have to comply with the Families First Coronavirus Response Act, the FLCRA, which provides for Family Medical Leave Act expansion. In this case, the employee must have worked for the employer for at least 30 days, and it provides leave available specifically to care for the employee's child, not the child of a brother or a sister or somebody else, if the place of care, or school in this instance, has been closed, or the child care provider is unavailable for reasons related to COVID. And this provision right now is set to last until January 1 of 2021. I don't know yet what the pending legislation is, or what's being discussed right now about any expansion here. But right now it provides up to 12 weeks of leave. And basically weeks 3 through 12 are paid at a 2/3 rate, up to a daily maximum of $200. And they also may be provided emergency paid sick time for those first 2 weeks out of that 12 weeks of leave. But this basically provides a new category of FMLA leave, and it also adds a partial paid provision to FMLA, because normally FMLA is unpaid. So if the employer has more than 500 employees, it does not need to comply with the FLCRA. But our recommendation, of course, is to still go through the process of speaking with the employee about what options might be available. It's an important process because it allows the employee to understand that the employer is really trying to work with them. And it lessens the chance that the employee would run to sue an employer if the employer ultimately has no choice but to terminate that employee. Now, understand that under this scenario with the asthmatic child, there's a possibility that the employee could claim that the real reason an employer is terminating them is because of their association with their child who has a disability, asthma. But of course, this is why employers will want to document their discussions with the employee and the efforts that they undertook to try to see what options there were for the employee in that situation to continue to work for them. If you could turn to the next slide, Brian. So Sally has been sending her child to brick and mortar school. However, it's now gone entirely virtual due to a recent COVID outbreak. She tells her employer, look, I have no one to watch my young child. He's in first grade. There's no way I could do the work that I need to do remotely. And she asked to take the FFCR expanded FMLA leave. Now, Sally's supervisor asks if another adult is available to watch her child. Sally says, no, there's no one else available. And Sally's supervisor somehow learns that Sally's husband has been laid off. And Sally's supervisor is telling HR, listen, I know her husband's at home. He can't be doing anything. Let's deny this expanded FMLA leave and not allow her to, take the paid leave time off. But what you need to understand is the DOL guidance explicitly states on the FFCRA that if Sally states that no one else is available to provide care, then the employer must accept that response and not make any sort of assumption. In this case, Sally's husband may be spending all of his time during the day looking for a job. He may be pounding the pavement looking for a job. And so there's all kinds of reasons why Sally has requested this leave. Michelle, why don't you weigh in on this from the employee aspect?
Sure. And I do want to add that there was recent guidance from the Department of Labor just this week that, and this, I think this was a question that was asked as well, that if your school district or school is giving you the choice between in-person or virtual, and you choose virtual, then that you would not be eligible for the leave under the FFCRA. So that is new guidance for people who choose the virtual option. So I think that applies to a lot of us here in Florida, where schools are open in person. But in my county, I think 2/3 of the people are home, and 1/3 of the kids are in person. But the people who are home would not necessarily be eligible for the leave under that new guidance. So that's just, they are constantly changing the guidance. And so it is important for employers to have good legal advice available to them because of these changes. For Sally's situation, I would also sort of talk to her about whether she can do her job with more flexible hours instead of taking the leave. Sort of explore other options to sort of think outside the normal workplace box. I have concerns about what happens when this 12 weeks is exhausted, especially for people who took this in the spring. I was home trying to teach my children and work at the same time, and it was impossible. So I'm hoping that, employers can be creative once that happens, although, with the flexible hours and things like that, that then you sort of walk into a wage and hour minefield. So you do need to be, mindful of all of the aspects of it. But, it is only 12 weeks, and that is going to be exhausted before COVID is over. So I have concerns about what happens then.
Absolutely. Okay, Brian, I think I'll turn it back over to you to discuss employees that say they are afraid to return to work.
Okay, thank you, Tyler. So a situation that I'm sure many of you out there listening have either encountered or will soon encounter is one where a furloughed employee has received a call to return to work, but doesn't want to go back to work because he or she is afraid of getting COVID-19 or spreading it to someone with whom they live. Now, the question that's bound to arise when that situation comes up is, can we terminate the employee? What do you think? Under those circumstances, can you terminate the employee? Okay, that's a bit of a trick question because regardless of how you answered it, that actually should not be the first question that your clients ask themselves. Again, it goes back to, just because you can doesn't mean you necessarily should. So in that situation, which I'm sure many of us are going to be encountering soon if we haven't encountered it already, what we should tell our clients is to inform the manager or supervisor to whom the employee voiced his or her concern about returning to work, that they really need to get HR involved. They need to get HR involved to have a discussion with the employee to understand exactly why he or she's unwilling to return to work. So this includes getting a written explanation from the employee as to all the reasons why he or she does not return to work. Now, what this interactive dialogue is going to do in getting that written paper from the employee is it will allow your client's HR department to determine a number of important things. First, it'll allow them to determine whether the employee has an underlying medical condition. It'll allow them to determine whether the employee lives with or is taking care of someone with an underlying medical condition. It will allow them to determine whether the employee is dealing with perhaps a mental health issue or whether or not the employee has any child care concerns. So once your client and its HR department or HR employees have all this information, they've gathered all the facts, they can determine what their legal obligations are going to be under federal, state, and local law, and what the best course of action is under those circumstances is going to be. Michelle, do you have any input that you'd like to give on this scenario?
Yeah, I think this is one where the legal advice might be, you know, if he doesn't, if Jose does not have an underlying medical condition or anything like that, then the answer might be that yes, you can terminate him. But do you really want to do that, or is there something that you can do? Can he work from home? Can he do something else? Can he be placed on a leave? You know, I would hope that employers are exploring all options, because there are people who are genuinely concerned about returning to work, even if they don't have an underlying condition themselves. So this is one where I think the legal answer and the answer I would like to see might be different.
Yeah, certainly. And again, it goes back to this whole idea about being flexible and exploring all the various scenarios and talking with your employees to find out what exactly is going on, and is it something that can temporarily be accommodated, even if it might not necessarily be something that you're legally obligated to do. With that, I'll go ahead and turn it back over to you, Tyler.
Thanks, Brian. And, you know, I saw a few questions pop up in the Q&A about requiring a doctor's note, certifying fitness for duty when employees who have gotten COVID return to work. The EEOC's guidance clearly says that yes, that inquiry is permitted, basically because it's not disability related and because of the pandemic. So you'd be justified to ask for a doctor's note certifying fitness for duty. So that's not the issue. The issue is when the employee says, I'm having trouble getting a doctor's note. So the EEOC says doctors and other healthcare providers may be too busy during immediately after the pandemic to provide like a full fitness for duty documentation. So you may want to take and explore with the employee new approaches. So, you know, as your HR professional may identify a local clinic that the person can go to and possibly get a form, a stamp, or maybe just an email back and forth from HR if the employee allows that and approves the communication and it doesn't get into disability or anything more than that. The point is really that I think the EEOC is imparting is that employers do need to have that flexibility and not say, you know, you didn't return our 3-page form from your medical provider. That's not good enough. You're fired. That's what the EEOC, I think, and probably plaintiffs, lawyers, and employees, I think, are clearly concerned about. So moving on to more issues associated with employees afraid to return to work and the legal landmines associated with that. Workplace safety legal issues could fall under the Occupation Safety and Health Administration Act, OSHA. So under OSHA, refusal to return to work due to unsafe conditions could be protected if the employee believes they are in, quote, imminent danger. What does that mean? Imminent danger is any conditions or practices in any place of employment which are such that a danger exists which can be reasonably expected to cause death or serious physical harm immediately or before the imminence of such danger can be eliminated. Obviously, this was written by a lawyer, we can tell, because there's a lot of qualifiers there. But look, we're seeing lawsuits filed in various jurisdictions associated with this. The employee claimed she was terminated after she stated she intended to work from home due to COVID concerns. An employee claimed she was terminated after choosing to self-isolate because of COVID symptoms. An employee claims that a restaurant employer threatened to terminate her if she wore a face mask. And hopefully because of local and state mandates on face mask wearing, that is not happening as much anymore. But I think that the issue here really is what is imminent danger. So if an employee is particularly susceptible and their job requires them to be close to another individual, and you tell them that's the only way they can do their job and there's nothing more you're going to do. You're not going to put up plexiglass between people and provide any personal protective equipment. The issue is the employer placing that employee in imminent danger in that scenario? I think whether those claims survive or where they go, time will tell. But I think it's important to identify those as at least potential claims, because if an employer doesn't want to get sued and wants to, treat its employees fairly, then it needs to consider this analysis. If you can go to the next slide, Brian. So going back to Jose, what if Jose's supervisor saw that he was complaining with other fellow employees on a Facebook post about being asked to return to work when he felt it was unsafe to do so? Well, this implicates the National Labor Relations Act. Section 7 of the NLRA extends statutory protection to employees who engage in protected concerted activity for the mutual aid or protection. And in this case, that's exactly what Jose is doing. It doesn't matter that he's not doing it on company time, that he's doing it on Facebook. He is complaining with other fellow employees about being asked to return to work and saying he feels like there are unsafe working conditions. That is protected concerted activity. This would also, what would also fall under the NLRA in Section 7 would be participating in a concerted refusal to work in unsafe working conditions, or even just talking with one or more fellow employees about unsafe working conditions at work, as long as they're, still working. It could also include joining with coworkers to talk to the media. So someone, goes on a local radio show to talk about what they perceive to be unsafe working conditions at their employers. And, a lot of employers have a real difficulty with this, because they say, how can they go on the radio and bash us as employers and we still have to employ them? But that's exactly what the National Labor Relations Act was designed to protect. And Michelle, do you have anything to add on NLRA claims? Anything you've seen?
Well, I kind of love these NLRA claims, the Facebook postings in, pre-social media and the internet. You kind of had these water cooler conversations. And now the water cooler has grown and people are having these conversations online. And the great thing about that is that they're having more conversations and there's a record of them. So I have seen people fired for Facebook posts. My first question is always, well, did a coworker comment on it? Because if it's just the person, out there bad-mouthing their employer, that is one thing. But if it's the employer and a coworker doing it, that's when you start to worry about concerted activity. And I know, under the NLRA is one, or the NLRB is one of those things that shifts with the administrations, with the politics of the administration. So under the Obama administration, they were really going after these sorts of claims. And under Trump, I think they've pulled back a little bit, although I think they still are saying that, yes, you can't do this. And I think a lot of employers are just not aware that they can't fire their employees for saying bad things. Just like they're not aware that they can't tell their employees not to discuss their wages, right? You have to allow your employees to discuss the terms and conditions of their employment. And right now that is it safe to work here in COVID? What are we doing?
Yeah, those are great points. And the wage thing is something that I can tell you some employers are almost shocked that they cannot prohibit their employees from talking about their wages, but you can't do it. I mean, it's as simple as that.
I had a C-suite level employee of one of the big banks tell me that was their rule. They just don't know.
Yeah, it's surprising, but it's there. So if you could turn to the next slide, Brian. We're running low on time here. We just got a couple of minutes. I don't want to call this the lightning round, but Michelle, I wanted to give you an opportunity to talk about something I think is very important. These are just kind of the mop-up, the kind of the other claims that are potentially out there to think about. But why don't you, in particular, talk about wage and hour claims and what you're seeing right now, and what this means. It has to do with minimum wage payments and overtime work under the Fair Labor Standards Act. So why don't you go ahead and talk about that if you could?
Sure. So wage and hour, real quickly, people are entitled to be paid a minimum wage. Nationally, that is $7.25, and it's higher in Florida. And then if you work over 40 hours in a work week, you are due time and a half your regular rate of pay. There are a million exemptions to that. There are people who are paid a salary and fall into certain categories of employment, and they don't need to be paid overtime. But the default is you are entitled to minimum wage and overtime. The issue we're seeing now is that people are working from home. And so it's real easy for employers to know when their employees are working, when they're in the office. It's a lot harder when they're at home. I will tell you, before all of this, I told my employees, like, they absolutely cannot have their email on their phone. I don't want them doing anything outside of work because I want to make sure that I'm paying them for all of their time, and I don't want them working at home. Now that's changed, right? They're home all or part of the time, and I need them to have stuff on their devices at home. So it is it's an issue, and there are ways to handle it as an employer, to say you're only supposed to work these hours. If you need to work outside of these hours, you need advance approval. But if the employer knows that their employees are working outside of those hours, then that defense isn't going to be available to them. Because it's, the language is suffer or permit somebody to work. So you can have all the rules you want saying no overtime, but if you're getting emails from your employees at 1 a.m., you know that they're working outside of the workday. So that's I think going to be the big issue. I'm not seeing a lot of that yet, but wage and hour stuff kind of happens later. Once somebody leaves a job, they'll come to see me and say, well, I didn't get paid for all of this time. But I suspect that is going to be an issue because of all of this working from home and people kind of working sort of short-staffed or working weird hours and trying to get through this year. And, there's a lot of, okay, we'll come together as a team and do this, but you still have to pay people when they do that.
Right. Yeah, absolutely. All sound advice. Brian, if you could advance to the next slide. And I did just want to circle back and address a question I saw in the Q&A about the Bob's situation and why we talked about requiring a return to work note from a doctor for Bob's return. The issue there that it may have been lost in the fact pattern, but Bob said to his supervisor in that scenario, my diabetes has really been making, or my high blood pressure, whatever his situation was, has been making it really hard for me to do this job. And so Bob, in doing that, is putting the employer on notice of potentially not being able to safely perform the duties of his job. And when an employee does that, you do have the right to talk to the employee and engage in a dialogue about having them submit a note that says they can safely perform the job, because you don't want an employee coming to work if doing the job will exacerbate their condition and they can't safely do the job. So, I mean, it's the employee, you put the employer on notice of that under that scenario. So you can see some of the other potential claims. We've only got about a minute here. I'll go ahead and go to the last slide. And, look, this is from the employer's perspective. Michelle, I'll give a chance for you to talk about the employee perspective. If you litigate cases involving COVID-19 considerations, employers need to be prepared to address what was happening in the country and the economy at the time, what the company knew as far as all the mandates go at the given time, and when did it know it, what guidance was coming from the CDC and the federal, state, and local government at the time, because that's going to be a critical issue that you're going to have to present to the jury. You're going to have to paint a picture of what was happening and what factored into the decision-making process that was going on at that time. Michelle, do you want to give any sort of final thoughts on from the employee's perspective in litigation involving COVID-19 considerations?
I don't know if I have anything specific to, how litigation is going to be affected. But I think that, as far as from an employee perspective, most people come to me after they're terminated, and in that case, all I can do is evaluate what happened. If people come to me ahead of time and I can give them advice on what to do or what the law is ahead of time, a lot of times we can make that situation work for them. And so I would say that, you know, in these times where the advice is changing and these laws are new, that seeking out proactively some legal advice from both the employer but also the employee perspective, I think is extra helpful this year.
Absolutely. Thanks so much, Michelle, and thanks so much, Brian. We want to leave you all with a slide here to join the Labor and Employment Law section of the Florida Bar. Here is the link. Make sure to jot it down. Join the section if you're interested in this. And we're so glad that you all could register and attend today's seminar. If there's anything else, Cullen, I think that'll be it for us.
Okay, great. Well, yeah, on behalf of the Young Lawyers Division, I want to thank our presenters. It was nice to hear from both the employer side and the employee side. I thought that was very good. So thank you to you. For those who have attended and are going to be applying for CLE credit, the number is 4150. That's 4150. I know there were a number of Q&As that we answered while this was going on, but because of time, we're not going to be able to continue the webinar. But unless there's an objection from Tyler, Brian, or Michelle, I would encourage you all to reach out to them individually if you have some specific questions. Thank you all for your time.